Good morning everybody, hello, welcome to my webinar today on Friday the 27th of September 2013. I'm Amanda Chadwick, I'm a senior speaker at Peninsula Business Services, and today we're going to talk about preventative measures to prevent really you going to a tribunal or ending up in a tribunal, and also we're going to talk about problems that can occur and lead to ending up in a tribunal as well. Today's webinar we're going to start off with really just a little bit about tribunals, some recent cases that we've handled. The hot topics are on our advice line. We're going to go through the right policies and procedures that you should be using as defence mechanisms and preventative measures. And then what we're going to talk about is we're going to talk about the tribunal reforms and what to do if you do receive tribunal papers. So we have actually got a jam-packed webinar today, so I hope that you enjoy it anyway. Right, okay, so just to let you know, first of all, when we've been established since 1983, and we currently integrate ourselves within 26,000 businesses throughout the UK. We're still a family-run firm, and we were started on the back of a tribunal that our director had, and he got it completely wrong. He lost out at tribunal, and he just couldn't believe the employment law experience that he had. As a result of that, in 1983, our director, Peter Doan, set up Peninsula Business Services, and now we're dedicated to employment tribunals, employment law and health and safety. Each year we handle over 3,000 employment tribunal claims, and each and every week our legal services team are bringing around 60 cases to conclusion on behalf of our new and retained clients. And I can tell you from experience that when people have a tribunal, they have an issue at work, and I'm speaking to them, it's always the person they thought would least likely to take them to tribunal. It's always the person that they've helped out, the one they've lent money to, altered their hours, they've been off with sick, with stress, depression, and they've really gone out of their way as an employer to support that individual, and that individual has ended up taking them to tribunal, and it's all the more shocking really. But from our experience, it's always the one you help the most. We are specialists in this field. Our caseload consists of purely employment tribunal and employment appeal tribunal matters. So it means we have some superb skills, expertise, focus to deal with any tribunal matter, understanding of employment law cases, and they are complex. Up to date, we have to be spot on with this ever-changing field of law, and teamwork. We've got a vast amount of knowledge along with the requisite advocacy skills and experience of tribunal proceedings to ensure that our clients are and their cases are in good hands. So what have we got with the tribunal update? Well, the HMCTS has published a report showing tribunal statistics for the period from the 1st of January to the 31st of March 2013 have showed a significant jump in the number of claims made in comparison to the same period in 2012. In fact, 36 more claims were in early 2013 were made than in early 2012, with a total number of 57,737. The number of claims made under the Working Time Directive, this is really crucial, that you've got to listen to this part. This is a massive claim, this. You know, we're talking about holiday pay here, the right to holidays, taking holidays, maximum working weeks. It's doubled in comparison to last year, making up just over a third of all claims. So people are getting it wrong, and they need to listen to me. Get it right. The holiday pay, and what's really scary about this is if I work for you, and you know, and I'm one of those really, really hard-working people that never take holidays, and I don't take the time off, and you keep saying take your holidays, where do you document that? Where do you manage it? It's all word of mouth. And do you know what? I can make a claim that goes back several years to you for holiday pay that's never been paid. And you know what? The only way that you're actually going to prove yourself innocent is with documentation, a paper trail, policies and procedures. So second in the list behind the working time claims was unlawful deductions from salary. They come hand in hand. They're married to each other, those two. Failure to make correct payment, etc., making up 16%, followed by unfair dismissal claims at 11%. So that's where we're up to, okay? So that tells me, you guys out there that are listening to me, you need to focus on the Working Time Directive. Working hours, breaks, maximum working hours, breaks between the shifts, making sure young workers are looked after, and making sure people are taking their blooming holidays. So, right, okay, tribunal update on our recent cases. Just thought I'd give you a couple of these little snippets. A cook who worked for a countrywide care home operator was made redundant. She brought a significant claim in the region of 30k before the employment tribunal on the basis that it was a sham redundancy, and the reason she'd been dismissed was because she had blown the whistle to the local authority regarding the operation of the care home.
There was significant press interest in this case. The cook had indeed blown the whistle, but we were unable to persuade the employment tribunal, we were able to persuade the employment tribunal that this was not the reason for dismissal, and the case was dismissed, saving our client 30 grand. Sex discrimination, constructive dismissal and breach of contract claim heard at Cardiff Tribunal. Amount claimed 46 grand, successfully defended, no award. Unfair dismissal and holiday pay claim heard at Liverpool Tribunal on the 8th of July. Amount claims 33 grand, successfully defended, no award. So what are the hot topics on our advice line? Well, we take about 60,000 calls every month on our advice line, and at the moment hot topic is 0-hour contracts, thanks to Vince Cable highlighting the use of 0-hour contracts, and I have to say it has increased in the last few months and the last couple of years because of people's funding, etc. Used in the right way, they're brilliant, but they've got to be used in the right way. That means that you've got to make sure their work status is clear and they are clearly on a 0-hour contract, you know, and you've got to make sure that it's not a familiar hours and regular work that you're giving to somebody. It truly is a 0-hour contract. So settlement agreements. They've replaced compromise agreements. That's a big question at the moment, how to use those. You've got to follow the code that's been set and the guidance by ACAS that goes along with the settlement agreements, else you might find yourself all over again in a tribunal because of them. So you've got to get it right. They are amazing if you get it right, okay? So I would seek legal advice if you enter into any settlement agreements. Pension and auto enrolment, hot topic at the moment where you might find yourself in a tribunal or problems later on. First of all, check out your staging date. Make sure you know what your staging date is and when you've got to auto-enroll your staff. Second thing is, when you know your staging date, the things that you've got to change are your statement of main terms to include the pension provider. You've got to update your employment law handbook to consider the changes for pension, but also the opt-out as well, and mention of pensions in there. And also what you have to do, absolutely crucial, is check your workforce status just to see who in your business actually is entitled to be auto-enrolled, and that's really crucial. So those are the elements of the Pension Act. The other questions are how to conduct a disciplinary. You know, even HR professionals and experienced managers are asking us how to conduct a disciplinary. And what I'd say to you is remember the three-step procedure and get this written down into your employment law handbook. Investigate, discipline, appeal, and grievance procedures as well. Legally, you've got to have those. If you haven't got them, you know, you're going to find yourself foul of the law if you end up in a tribunal. And there's, for each of the steps, there's explicit details of what you should be following. Conduct and capability as well. How do I manage somebody whose conduct's bad? That's when they don't want to do the job. And capability when they can't do the job, which is long-term sickness, short-term sickness, always a hot topic. Reducing suspension costs in the health sector. That is actually a huge question because the governing bodies around the health sector and similar organisations dictate how that you have to suspend your staff straight away when an investigation occurs, and it can go on for quite a while, and it's on full pay in most cases. And also the other one is, have I missed any major changes? You always find that a lot of people ring up and go, gosh, I might have been asleep the past few months, let me know of any major changes. So that's really the hot topics on our advice line at the moment. And then obviously particular issues in accordance with their business. So, okay, top 10 common pitfalls where people end up in a tribunal is not issuing the statement of main terms. Look, I come for a job with you, I sit down, have an interview with you, you tell me about your company, and hopefully you're selling your company as much as possible. I'm sat there and I'm asking you about your company. I'm asking you about the job, because if I get the job and I go home to my husband, I'm going to tell him where I'm working, how much I'm getting paid, the hours of work, the holidays I get, etc., and my perks and benefits. That is what we would refer to as your statement of main terms. It should also include the employer's address and the employer as well. That is a legal document that is required by law to be issued within 8 weeks. If you don't issue it, guess what? You find yourself foul of the law, and if you're not issuing this, if you end up in a tribunal, it's costly to the employer, the equivalent of 4 weeks' wages, and all because they didn't issue the employee with the correct documentation. The average award for failing to issue a statement of main terms is nearly £1.5 grand. That's just automatic straight away. That's without any other awards on top of that. So bear in mind, you know, I wouldn't actually take a job off you if you didn't give me a statement of main terms, and I would send that to somebody when I offer them the job. So that's when somebody is offered the job on an offer letter. Okay, and in the offer letter it says the start date, etc. But then what we're going to do is we're also going to make sure that we include the statement of main terms, and that would have all the legalities of the job, okay, and the benefits. So that's really, really crucial. I still know employers, I meet them at my seminars when I host them, and they say, oh gosh, I haven't even got statement of main terms in place. I know there's people out there that are operating without statement of main terms. However, Tribunal, automatic award, nearly £1.5 grand. Top 10, number 1. So we've got then the job description, okay? The job description is if you were writing an advert and you know you need somebody for the job, okay? So I know I need somebody to fill this vacancy. I've got a vacancy. The job description is all about the vacancy. It tells them about the job roles, it tells them about what they'll be doing, their skills, but also as well what it does say is it says who they'd be reporting to or who'd be reporting to them. Job description is absolutely crucial because later on we will be using the job description when we're managing somebody's performance under KPIs and appraisal systems. So we've got to have job descriptions in place. They form part of the contract. So we need job descriptions in place when we take somebody on. I want you to have job descriptions for every single worker that you've got in the workplace because then you can manage their performance and manage them effectively. Alongside job description, by the way, if you advertise, and I haven't put it on there, is job specification, personal specification. So you know you need somebody to fill the vacancy. What I'd also like to have now is I'd actually like a job specification which tells me who I'm looking for the job, personal specification. So it says the type of skills they need, the type of qualifications if applicable, etc. And it tells you about the personal attributes of that person. So that's what would go alongside job description really. So job description, personal specification, written exclusively to that particular role that's being advertised. Standards and expectation, amazing part of the business because these are the rules of your company. When you hear standards and expectations, I couldn't run a business without standards and expectations in place. And also, we're going to put these in the handbook. This is what we call conditions of employment. Now, the handbook, as you hear me say at lots of other webinars, is 90% of that is, you know, your rules basically, and 10% is the law, such as the disciplinary rules, the grievance procedures, appeal procedures. Those are what you have to have in place written in your handbook by law or somewhere, but we would recommend them in a handbook. That's the best thing. But what we would say is that in the handbook you can have whatever you want in your handbook because it's your company, but remember to be reasonable. If they're not reasonable, you fall foul of the law. It's as simple as that. But make sure they're reasonable. So to say to somebody, I'm going to search you, that's reasonable. To say to somebody that you can't talk about my company, you can't, you know, obviously nice, let me go back to search. I can search you. I'm not on about taking their clothes off here. I'm on about you not touching them because that's assault. And always remember I'm giving you an overview on law on these webinars. But a search policy is reasonable. To say you can't use your mobile phone in the workplace and to use the landline for emergencies, that's reasonable. To have a mobile phone policy, social networking policy, to have all that is reasonable in a handbook. And basically what I would do if I was recruiting somebody, I'd say, you want the job with me? Here's my handbook. Yeah, so and you sign for those rules and agree to those rules. That's how you request a holiday. That's how you ring in sick, no texting. That's how you leave the company. You know, I pay for your training, you pay me back if you leave within a year. Those are my rules. This is my handbook. It's as simple as that. People expect rules on how to take breaks and holidays, etc. So that's your standards and expectations. In there should be written disciplinary rules and procedures in accordance with the ACAS Code of Practice, written grievance rules and procedures as well, and that's excellent because if anybody's unhappy about something, having grievance procedures in place gives you the opportunity to sort them out anyway. Capability policies and procedures. So we've got capability policies here, we've got capability procedures to self-helpers really, going through, you know, if somebody's off with ill health, long-term, short-term, but the big one is lack of dexterity because they've got personal problems that are affecting them, such as debt, family problems, relationship issues, other issues that they may have, gambling, addictions, drugs, alcohol. So it would help you go through that process with capability, policies and procedures. Also, using KPIs and appraisal systems to manage your staff is absolutely brilliant because if you haven't got them, how can you manage your staff? How can you say this is the benchmark and we're working against that and to that? You know, so KPIs, key performance indicators, and appraisal systems. I want those in place. If you haven't got those in place, you haven't got evidence of how your business works. Create a paper trail. Loads of people do not create a paper trail. They do everything word of mouth because quite often they're actively part of the business. So what happens is I might work for you and I might be a part-time worker and I might want to work full-time again. You know, and I request to work full-time. Don't do that verbally. Do it, say, please put your request in writing and respond in writing by using documentation and forms and letters. I'm telling you now, your staff are keeping paper trails on you. You keep paper trails on your staff. And if you're sick of paperwork, have a look at our HR online service. It's absolutely brilliant. Training and education of management and employees, you know, keep up to date. Remember, you've got vicarious liability for the actions of your staff. So make sure your managers are trained. Be aware of the industry they've come from and then when they'll start working for you and what environment they've been working and within before, which may have an impact on the way they treat people in the future. So training and education of management and employees, one of the top 10 common pitfalls which people don't follow. And keep up to date with employment law changes. Things can change, usually April and October, so keep up to date. So what documents should you be using to prevent tribunals? Well, statement of main terms we spoke about. That's my personal contractual terms with you. If you want to change that, by the way, you have to, you know, consult with me and talk to me about it. It may be a request that I've made for going from part-time to full-time. Make sure you change the statement of main terms when I've requested such a dramatic change to my employment with you. Make sure that you issue those, as I said, within 8 weeks, and make sure you keep a copy of keep a copy in the employee file. Also, it's the employee handbook, as I spoke about before, that contains all the conditions of employment, your rules. Keep up to date with that. Make sure you're aware of any changes that come in. And also, remember, don't copy somebody else's employment law handbook because they're industry specific and tailor-made. And don't be alarmed to put new policies and procedures in place. You've got to keep ahead of the times. For example, at the moment, the social networking policies and the mobile phone policies, we have to keep ahead all the time. We've got social networking, Google, LinkedIn, Instagram. We've got everything. So you've got to give like a massive paragraph, an overview on internet policies and procedures, etc. So the employment law handbook, you've got to keep up to date on that, and you've got to make sure that all your staff get it. The best time to hand this out is actually on induction on day one, and get them to sign to say they've read it. And for me, legally, understand is a winning word. So to understand the employment law handbook, I've read and understood it. Application forms as well, a brilliant way to stop fraud and deception, to stop tribunals, but only if they say that they're a legal document. And I always use the example, don't I, of the telephone answering company where a man sees a job advertised for them, applies for the job, sends off a CV by recorded delivery and doesn't get even a response off them. A few days later, the job's still advertised, he's still not heard, and so he sends a CV off by recorded delivery in a woman's name. Guess what? She gets an interview. And, you know, it's sexual discrimination. Why didn't he get an interview and why did she? And the reason he got away with it is because it's on a CV. A CV isn't a legal document, but an application form is if it says it. So what you're doing is you're standardising your documents and you're preventing fraud and deception by using an application form right at the early stage. And then we've got interview rating cards. Those are amazing tools to use. Once you've got your job description in place and your personal specification, you'll know how to weight up and point system your interview rating cards and get it right. So, and then, you know, if you're interviewing like 50 people, how are you going to know all the points for every person? So you're keeping notes on there, and then you can file them away. And if somebody queries why they didn't get a job, you can refer to the interview rating card straight away and say, look, actually, you only scored so much here, whereas a lot of the other people on average scored this amount, so that's why you didn't get the job. And also on the interview rating card, a large percentage of that can be made up of personality, because that plays a huge part, doesn't it, in some industries and working with people. So then we've got holiday requests, making sure that people know how to request the holidays, holiday request forms, and making sure that, they know that they've got to take them, and you've got to manage them as well.
Return to work. Always doing a return to work interview, always sitting somebody down and saying, why were you off? Did you visit a doctor? Are you taking medication? Are you well enough to be into work, come into work? That's a return to work document. And what you're doing is you're saying to the people that take the odd days, the odd dayers, that you're taking it seriously. Why were you off? Oh, I had a bad stomach. You feel like going, not again. But you're not going to say that. Please don't say that. And then, are you taking medication? They say no, and you think, I didn't think so. And then, what you're doing is you're controlling the situation. And by sitting down with them, even for one day, you're taking it seriously. And I can tell you now, it'll stop sickness. So by doing a return to work interview, it's fabulous. But the other reason why is for health and safety as well, because you don't know what happened the night before. Somebody could have had an injection of some sort through the doctor, and then they could come in work and they couldn't be well enough to operate machinery. So return to work. So return to work interviews, and also it's the management of long-term sick as well, because these eventually, will be used as evidence if ever you have a tribunal or you're dismissing somebody on the grounds of capability. Sickness injury records scream out for themselves. Exit interview documentation, just sitting and doing an exit interview can help you find out a little bit about your business and the personalities of your managers as well, because people that are leaving are more likely to tell you who they like and who they don't like. So an exit interview is absolutely amazing to do. You'll find out tons about your business, but at the same time, it's stopping fraudulent claims later on in a tribunal where somebody changes their mind as to why they left you. Oh, I'm leaving because I've got a really lovely job with more money and a car, and then later on I say, actually, the reason I left is because I was being sexually harassed and bullied. Yet they didn't say that at the exit interview, and they've written on one of your defence documents they're leaving because they've got a new job and more money and a car. And when you ring up the new employer, they say they don't work here anymore, and now you know why. They're trying to take you to tribunal. So exit interview is an amazing document to use. And then we've got staff appraisals and KPI systems, which I spoke about earlier on. Key performance indicator, saw those really in the early 80s. And key performance indicators, if we go back to really the very first industry that would use something like that, would be, machinists in factories, people that make things, where they'd have like 10 people working in the factory, and they'd say, how many garments have you sewn? And somebody else would say like 5. How many do you sew? 5. And then what they do is they add up all the garments the 10 people have sewn within an hour, and then they divide that by the 10 to work out the average. And then that was the benchmark for everybody to be working against. And that's how they could work on somebody's performance, and also then introduce staff appraisals and pay rises. But also by having staff appraisals, you see, and using the documentation surrounding that, making sure you fill it in at the exact time you're having the staff appraisal and the notes, what you're doing is you're finding out about your staff and skills, etc. Because how often do you speak to your staff and find out about them? How often do you find out how much they've done on PowerPoint, for example, how far they are on Microsoft Word, how have they got any other skills such as languages? And you could utilise those if you're securing contracts in other countries. So, that's what staff appraisal is about. It's about getting to speak to your staff and getting to know them and talk to them. And just a little top tip here, when you do your staff appraisal, if you can't afford pay rises, but the person has outshone themselves, why not upgrade their job title? Because, recognition sometimes plays a better part in employment life than actually a pay rise. So staff appraisals is an amazing thing to do. Okay, so what policies? I've just put a few here for you because I'm giving you an overview. If I wrote down every policy I'd recommend, I'd be here all day. Now, I don't mind, but I know your attention span fails after 40 minutes. So I'm going to just talk about a few of the policies. Okay, you've got to have a sickness policy, injury payment and conditions policy. You have to, because sickness happens within the workplace. Is that not the hottest topic at the moment in business life? How do I reduce sickness? Well, I can tell you, use return to work interviews and manage it. Don't put up with it. And put a capability policy and procedures in place to help you manage it. It's not always about sickness, is it? It might be other reasons. It might be the job itself. And you'll only know by speaking to your staff and doing return to work interviews. What are the policies? Disciplinary rules and procedures. I've told you about that. There's set rules that you've got to follow. Capability policies and procedures help you with other things apart from sickness, long-term and short-term, but lack of dexterity, training issues, etc. Appeal procedures, because every time you go through a disciplinary, that somebody has the right to appeal against it. So appeal procedures. Grievance procedures introduced by the tribunals themselves, because they felt that a lot of tribunals ended up at a tribunal and didn't need to.
A lot of the issues could have been sorted out within the first few months of the issue arising in the workplace by the employer. If they'd have had grievance procedures in place, they made them the law. You've got to have them in place. It gives you a chance to sort out issues in the first place within work by speaking to your staff and getting it heard. And if an employee is asking you to investigate, okay? Look at CCTV footage, look at evidence, and speak to witnesses. So then we've got equal opportunity policies, bullying and harassment policies, equal opportunity. What have we got now? We've got race, discrimination. Hang on, excuse me, just choking on my webinar. So we've got race, religion, religious belief, no belief, environmental belief, political opinion, affiliation, marital status, disability, gender, gender reassignment, sexual orientation, marital status. I think I've covered all of them there. I do that by memory, by the way. That's how often I speak about that. But an equal opportunity policy, bullying and harassment policy. By having these policies in place, you're giving yourself a chance to sort things out within the workplace and saying we take this seriously. If ever you feel that you've been harassed in any way or discriminated against because of these core reasons, then here we go, you make a complaint and we deal with it and we take it seriously and we document it every step of the way. Bullying and harassment, for example, that policy there, you might not think it's bullying and harassment, and what somebody can view as bullying and harassment, you might be less sensitive than another person. So you might have a young worker come in, and the ladies might grab that person who might be a boy and give him a cuddle and say, "Oh, welcome, you're welcome here," and he might find that a bit too in his personal space. So it's a really, really good idea to have the bullying and harassment policy in place, because if somebody feels that somebody's attitude towards them is affecting them in any way, there is a particular process to follow. And it could be what we suggest in our bullying and harassment policy is to have a confidential helper as well, who is a worker that's going to stay neutral to the whole situation, but help the individual write letters or approach the person that they feel is bullying and harass them, to let them know what is making them feel uncomfortable. So brilliant policies to have, because they're preventative, I think. Search policy, don't be afraid of having a search policy. The most common things that go missing in the workplace: coffee, tea, sugar, because they're household essentials, toilet rolls, also things like cash, obviously, time, overtime, petrol. These are types of things that we come across quite a lot, they have to be managed. And if you imagine if every single member of your staff took a pencil home and a pen and a ream of paper, how much does that cost you per year? Tally it up. So just to say, this is, at first it's to make everybody aware of what you consider theft, and to say, and I know when I first started work in the early 80s, my mum fostered lots of children, and I was one of 7 anyway, and my boss used to say to me, help yourself to paper, help yourself to pencils for the kids, and I did. Every week I'd take pencils and pens home for the children because they played with them. And now, when I think about it now, years later, that wasn't her company, was it? So, well, you don't know that, but it wasn't her company. But it wasn't her company. And that's me taking a ream of paper and a handful of pencils home every week with the permission of my boss. Times that by 52. That's the losses to the company. So if you think about it that way, we've got to say, I know it doesn't seem offensive, but that's not acceptable. If everybody took a toilet roll home with them, and believe you me, it happens, times that by, the amount of staff you've got, work that out. Or if you're working in a nursery, if people are taking packets of nappies home and wipes, times that by 52, that's my losses. So a search policy, though, isn't just for stealing, though. It's for alcohol abuse, drug abuse, and when somebody's smoking or using a mobile phone when they shouldn't be. A search policy is there to search your lockers, your own vehicles when somebody's driving them, and also, to search their vehicle if it's parked on your premises, but only with written agreement. So I'm giving you an overview on this today. But the search policy is an amazing tool to have, because it's useful for a situation where you want to search somebody or somebody volunteers, but you can only do that with a search policy in place. So social networking policy, oh my goodness me,
so many people now are asking us about social networking. I've been talking about it for years and I've not been taken seriously about it. And now everybody's going, oh my gosh, I need to get this sorted out. I have been talking about it. I must have been talking about the internet and social networking for near on 10 years now, and mobile phones, and saying how serious it should be along with the search policy. And it really is. I can't tell you how we're seeing this affect people's workplaces. We've got people bullying each other on Facebook. We've got employees talking about employers on Facebook in their work time. We've got people that work in confidential environments posting things on YouTube, etc., from their workplace, doing blogs. We've got the mention, some people have, how would I call it, a colourful private life. Not that I'm envious or anything, but, they've got a colourful private life. But what they do is they post it onto Facebook or any of the other social networking sites. And what happens is they say who their employer is. Now, if they're working in a certain industry, like with children, it looks unsavoury. And I bet you the Sun newspaper would get hold of it like nobody's business. So what you've got to say to your staff is, we don't mind you using social networking. That's the way to go anyway. But what we request is that you don't say where you work. You can say what industry, but you can't say you work for me. And also, make sure you don't talk in the social networking policy. You don't talk about my company without prior permission on any social networking site, Facebook, and you have it as a written agreement. And you link that to gross misconduct and misconduct, etc. So then we've got data protection. Remember, I've linked that to that because data protection. It's going to be big news within the next two years, I guarantee you. People have cameras up at work. People have tracking devices in the mobile phones, tracking devices in cars. In fact, I think my husband's got a tracking device on my mobile phone because every time he rings me, he goes, where are you? And I'm always in the shop. So when I'm not working, that is. And what happens is, you can actually have a tracking device on your mobile phone, but employers are using it without telling their staff they're using it. So if you're going to track your staff, if you're going to have a tracking device on the car and use it as evidence when it comes to disciplinary or investigation issues, or you're actually going to have CCTV, do you know what? You've got to put it in your handbook to let them know that you're doing it. Otherwise, it's a data protection issue. Also with mobile phones, quite clearly, when I join your company, go, welcome, Amanda. Here you go. Here's your company mobile. Now, that company mobile is for company use. So that means that, if you take a picture of yourself and post it to your husband, that we can see it. If you send a text to your mate and you don't want us to read what's in there, then don't write a text on our company mobile. Don't send emails. Don't send company work emails from your work's mobile to your home, and have rules with it. But make it really clear at the beginning, because don't have any surprises for your employees. So make it very, very clear through each of the policies why they're there. Listen, here's the mobile phone. Use it just for work, okay? Have your personal mobile for personal use. That is just for work. Everything you do on there, we can see. And we can use that as evidence later on if it's, malicious or harmful to our company. So you make it perfectly clear by having these policies in place. And then the internet policy, by the way, is saying that you can actually analyse and monitor the internet as they're using it. So letting them know you do that, and email usage as well. This is just some of it. Like I said, I could go on all day. We've got maternity policies. I don't really I'm not a big lover of huge policies on maternity because they change all the time. I just like a statement, because the biggest mistake, when I listen to our clients and I listen to people that join our companies, the biggest mistakes they make is that they don't know. And they're employers that don't know about their staff. Because how do you know when somebody's pregnant? You don't, do you? Unless obviously you're the father of the child. But you don't know unless somebody tells you. So that's my point. Why the hell have a massive, huge maternity policy? Introduce that later and talk about maternity with them when they've told you. But why have that maternity policy? Because where is that protecting your company? What I would have is a statement, and it says that when you become pregnant, you have to let me know written at the earliest stage possible, so I can make the health and safety standards necessary for you for your job, but also protect you at the same time. So what that means is that if they don't tell you and you dismiss them, or they lose the baby as a result of the job, then what you've got is you've got evidence there to say, I actually had a written agreement that they signed for that said they should have told me. So to say, I
we'll let you know, written at the earliest stage possible. That's a brilliant policy to have for maternity. Holidays, it's protective, isn't it, if you think about it? Holidays, they're, as I said, working time directive. You should be managing them all the way through the holiday year. And then remember that they accrue holidays as well during sickness. But there is a legal requirement on the maximum they can take. And also we need to have something written in the holiday request policy. And then sickness as well. How about sickness? They can actually claim back holidays when they've been on sick, as I said. But what about when they're abroad? We need a sickness note. So write that there. Write that in the sickness policy. And the new one is texting in. I'm not coming in today, but who ends up getting the text? And do they get it earlier on? No, they get it several hours later when they're all stressed about why Amanda's not come in. So have a sickness policy, a stress policy, and manage it. Wastage policy. Wastage, you know, you're probably thinking, oh, it's about people that waste paper, waste time. Well, it is all that, but it's more than that. It's for people that lose your shutter keys. It's for people that don't lock doors and you have a theft. It's for people that damage your cars by going up the curb or damaging the wing mirrors or denting the bumper. It's for those people that waste your money or maliciously damage your things. Having a wastage policy in place allows you to claim the money back. So get a wastage policy in place, cost cutting and cost saving. Training policy, I briefly spoke about that earlier on, didn't I? If I work for you and I leave within a year of my training, I owe you the money back. So like a training policy. And then obviously data and inventions policy, probationary suitability clause, so having a probationary period there that you can extend up to 6 months, but also having a suitability clause written into it to say, well actually if you're not suitable, we don't have to give you a reason, we're just going to say please leave. You know, so a suitability clause, and then obviously make sure that those policies are assorted, the business appropriate and the tailor-made. And remember, what might be gross misconduct in one industry might not be in another. So, top 10 hints and tips for dismissing an employee and not ending up at a tribunal. And then we're going to go through what to do if you do get tribunal papers. Won't take me very long. And also the tribunal reforms as well. So, have a disciplinary procedure in place, please. Make sure employees are aware of the procedure and what misconduct is. No surprises there. Fact, be careful of assumptions. Sack an employee based on assumption may lead you to an employment tribunal. Let the facts speak for themselves. Aim to be fair, consistent and reasonable in the application of the disciplinary procedure, and this will help to avoid tribunals. Follow your processes, not your best mates who's an HR officer, not somebody who's a solicitor that deals with the conveyancing. Follow your processes. If you spent money to have them written for you, use them, yeah? Balanced and neutral language. Remain calm and in control. Don't prejudge or preconsider. Consider and reflect. And consider the bigger picture as well. We don't want a tribunal. We want to get this sorted. So, what do you do if you receive tribunal papers? Well, sometimes, despite your best efforts, after all I've said, to be fair and resolve, you try and be fair and try to resolve the issues, you can end up with an employment tribunal claim being brought against you. If this happens, there are some simple steps you need to follow to handle this at the early stages. Well, don't ignore, first of all, don't shove that paper under your bills. Sit down somewhere quiet and fully read the claim. Pay attention to the detail. It's important to read all of it, including employment dates, job title and salary information, and make a note of any information that is missing or seems wrong. And if you don't, I can tell you what, you're shown up in a tribunal later on because the chairpersons know how to pick that out. The date. Look at the date. Remember the date. The tribunal letter will also tell you the date you have to respond by. If you want to defend the claim, this is absolutely crucial. Make a clear note of this date so you can make sure you don't run out of time. Remember, the tribunal accepting the claim does not mean that they think it will succeed. It just means that the person bringing it has shown on paper that they can bring a claim of this kind. The claim. Carefully read the details of the claim. This can be hard work, so if you find that you are struggling to concentrate or are getting extremely angry, then take regular breaks and read it in stages. Take notes. You may find it easier to follow if you take short notes setting out the main issues, so it is simpler. So once you've read the claim, you need to decide whether or not you think the claimant is right. You may find that they have got the facts wrong, or alternatively that the facts are correct but they have been misinterpreted. And then remember defence documents. Start gathering together irrelevant documents that you can prepare your defence. So you need to take it seriously, treat the claim as a priority. It can be very tempting to put it to one side to deal with later, but the time limit for dealing with it will soon run out, and it can take longer than you might think to write your response, particularly if there are a lot of issues you have to address. If you need help, you need to decide if you want to handle the case yourself, stressful, or if you want to appoint a representative. These claims can be surprisingly time-confusing and stressful and can be difficult to handle on your own, particularly if they contain complex legal issues. You can appoint representatives at any stage in the proceedings, but the earlier you get them involved, the more they can do. Here at Peninsula, our Legal Services Department is specifically set up to handle employment tribunal cases at every stage. We get them right, we take people on that have already got tribunals, and quite often we can get involved right at the very end. So, at any stage. So around the same time as you receive the claim, you'll also be contacted by ACAS. Their role is to see if the dispute can be resolved without the need for a tribunal hearing. Remember that negotiations through ACAS do not mean that the deadline for submitting your response has been put on hold. If you appoint representatives, then they will carry out the negotiations and discussions with ACAS on your behalf. Don't be pushed into settling though. If you think you're right, you've got to fight it. So, on July the 29th this year, the biggest reforms in tribunal procedures happened, in 25 years. It means if you lose an employment tribunal or appeal claim, you will have to pay the court fees. So the reasoning behind this, let's talk about this for a second, and then I'm going to make it really simple for you. In December 2011, the Ministry of Justice published a consultation paper on proposals for the introduction of fees in employment tribunals and the Employment Appeal Tribunal. That's EAT. So from now on, I'm going to say EAT, EAT, okay? The government justifies its decision by highlighting the employment tribunal system to be the only legal challenge route in the UK that can be made for free, and therefore the government wished to provide parity amongst other court systems. Yeah, it reportedly costs the taxpayer £84 million per year to operate the employment tribunal service and £2.5 million for the EAT, and the savings had to come from somewhere. So basically they're going to start charging people to take their employer to tribunal, and that's one of the many measures proposed in a bid to see a reduction in claims. Already we've had the increase of the unfair dismissal service qualification from 1 to 2 years. That's happened in the past as well. It's not made a change to us, in the government's hope that this will affect the number of claims made each year. So, of those that are consequently not debarred from making a claim by their qualifying service, so the 2-year thing, only those who can afford to pay the fee will be able to use the system. However, a remission system will be put in place for those who are deemed unable to pay the fee, and the fee will be waived. So let's make that simple. If you're not met the 2-year qualification, you can't make a claim, but you can really, can't you? Because you probably make a claim for discrimination or something else. Only those who can afford to pay the fee will be able to use the system, but we've got a remission system in place, and my experience is generally if you've lost your job, you're on low income because you might not be working, so you actually fall into the remission system, won't you? So we'll talk about that later on. The introduction of fees will not affect the claimant only. The fee system will initially place a burden on the claimant, but employers do not get away scot-free. No fee will be charged to lodge a defence, but there are prices attached to certain procedural applications that the employer will have to foot the bill for. Should a tribunal judgment be appealed, the party who appeals, this could obviously include the employer, will have to pay the appeal fees. The system has been challenged on access to justice fronts because the probability of an unfairly treated or unfairly dismissed employee giving up on their rights just because they cannot afford the fee and do not qualify for remission may be high. This will be felt all the more in unfair dismissal or discrimination cases. Total fees attached to these claims in excess of £1,000. But as I said to you, a lot of people may not have another job. So, after proposing 2 separate methods, the government decided to opt for a 2-stage process of fee charging. Sums will depend on the type of claim. So we've got type A claims and type B claims basically. So some claims that we're going to talk about fall into type A, and there's a different payment for that, and some claims are type B. Also what stage the process is. So initial fee will be payable on making the claim, so put your papers in and then pay the first fee, and then a higher fee payable if the claim is to be heard. Fees will vary if a claim is made which involves multiple claimants, so many people taking the same employer to tribunal. The alleged reasoning behind the 2-stage process is that claimants will theoretically be more prepared to look at alternative resolutions for their dispute, having already shown their intentions to the employer by making a claim. but not wanting to pay the surprisingly large hearing fee. So this is the fees. Just a summary. Oops, let's go back again. Right, two-stage process of fee charging, A and B type claims, and the reason behind it is because it costs the tribunals a lot to operate this. So we've also got here type A claims, breach contract. These are the type A claims. Failure to provide statement of terms and conditions. I spoke about that, didn't I? Failure to pay redundancy. Failure of employer to allow worker to take or be paid annual leave. Working time directive. Failure to pay wages or make an unauthorised deductions and equal pay. Type B examples: unfair dismissal, automatically unfair dismissal. Discrimination, less favourable treatment due to fixed term or part-time status. Failure to provide written reasons for dismissal. And so those are the type A claims, and this is the issue fee. So when I issue my paper, I then pay £160. To get it heard, I pay a further £230. Single claims, I'd say the person that's paying a fee is quite determined to get this case and thinks they're right. Single claims, type B, issue fee £250, and then the hearing fee £950. And then we've got the multiple claims, that's for more claimants, you see. Try not to write this down because you'll be here all day. These slides will be available later on YouTube, just so you know. Okay, those are the fees. So, many people on low incomes may not be required to pay the full fees. Opinion is that initially tribunal claims will drop drastically after implementation. I would say don't hold your breath. However, it is unlikely to put off high-earning senior manager employees, and low-earning staff may receive reduced or fee-free claims. It is also doubtful that the system will encourage early settlement, as there would have been a number of opportunities to resolve the matter through alternative resolution methods. In addition, an employer may not want to set a precedent to other staff by settling early, so literally creating cancer in the workplace by settling, because everybody else thinks that's what they're going to do anyway. Listen, I've given you such a jam-packed webinar today with a lot of information here. I hope I've helped you. These slides will be available later on, and the recording on YouTube on our link. So you can see in front of you now our link for YouTube, which is www.youtube.com/PBS Press Office. Okay, that's the link for YouTube. Now you can see any previous recordings of mine on there as well. We've covered quite a lot in the last few weeks. I host face-to-face seminars, and I'm currently going around the country with my colleague David, a pensions expert, and I picked one that's simple. No, I don't mean simple. I mean simple, like simple terms used, easy to understand, because I'm not a great listener. And we're working with this pension provider and our tribunals department and myself and David. We're presenting pension events all throughout the UK. And they're going really, really well. We've got a lot of employees turning up for them to get the basics on pensions, because it is a hot topic. They're free to attend. So if you'd like to attend one of our seminars that are on pensions, contact me at amanda@peninsula-uk.com. That email comes direct to me, and I'll forward it on to my colleague Robert Warner, who's actually heading this up. Also, so you get an invite. If you would like to attend any of my face-to-face events that I'm doing throughout the UK, on just an overview really on employment law, again, contact me at amanda@peninsula-uk. It may not be an event that I'm hosting, but hopefully it will be, and I get to meet you. Also, if you are a Peninsula client, you know what, don't sit there struggling to write policies and procedures or update them. Remember, that's what we're there for. You are our client. If you want an advert writing, a letter writing, you want help with any aspect of employment law, you're our client. So use our advice line as often as you want. We're there for you. We're there to support you from every aspect of recruitment to if you did have a tribunal and dismissal. If you're not a Peninsula client, you'd like to know more about what we do, and you'd like some free advice either over email or face-to-face, or you want a critique of your contracts, what you've got in place, and some help, or you're involved in a tribunal at the moment and you wouldn't mind us looking at what you've got in place, then it's no problem for us. You can contact me, and this is my email again as well. It's free at peninsula-uk.com. Now, I hope that you've enjoyed today's webinar, and if you would like any editorial written for free for your clients, or you'd like us to contribute to a website that you have, or you'd like us to have a speaker at an association or federation, or one of you a webinar for your clients, you know, again, contact me on email. I can arrange that for you. I hope you've enjoyed it today, and thank you so much for listening to me. And do you know what? Have a lovely weekend. I hope the weather stays as good as it is now. Thank you very much. Bye-bye.